Welcome to Husch Blackwell's Labor Law Insider Podcast. This is your host, Tom Godar. I've been practicing in the labor law sector for, more than 40 years, and I can tell you that in no time of my practice has labor law had greater changes than in the last 5-6 years. We began the podcast in May of 2021 following the election of President Biden, and elections have consequences, and under the Biden administration, a new National Labor Relations Board with a new general counsel reshaped labor policies, and they were very consequential. During that time, because it was so important to stay on top of labor law issues, the family of Husch Blackwell Labor Law Counsel more than doubled in its coast-to-coast reach to assist our client. Well, we've since had another election. In the January of 2025, President Trump was inaugurated to his second but non-continuous term. And once again, we're seeing significant changes in how the National Labor Relations Board and its appointed members, the GC right now an acting general counsel, and the board members are going to interpret the National Labor Relations Act and its associated laws. So once again, we're continuing a wild ride of labor law. It's not likely to change soon, so buckle up and enjoy the Labor Law Insider Podcast. It is great to have you back for part 2 of our discussion regarding labor arbitrations, those arbitrations which primarily arise in the context of a collective bargaining agreement. We have with us, and you know these fellas if you listen to part 1, 2 consummate insiders regarding arbitrations. My friend and colleague and partner, John Anderson, who has worked in the labor law world for, about the same amount of time as I have. In fact, we graduated the same year. John down at Marquette, I was at the University of Wisconsin, and we are just children in this area compared to the true dean of arbitrations in this state, Wisconsin, and quite honestly around the nation. People speak with respect of Howard Bellman, his experience, his insights, and the way in which he works towards resolution. Howard and John, welcome back. Thank you so much for joining us on the Labor Law Insider. And I want to begin with a question for you, Howard. What's your role in helping parties, even before you, quote, go on the record? And maybe it's even after you've gone on the record, but to find a resolution that they shake hands with on the way out of the room before they get a decision. And I guess the second part is, too many of the hearings, in my estimation, are no longer face-to-face. John is not driving to Minneapolis to try that case. It's now tried, as we're doing right now, virtually. We're not in the same room. You can take it in any stretch you want, but I guess it is, you often find a resolution before you have to write a decision. Is that impeded at all by the fact that we've now become a virtual sort of world?
Well, it's not a world I'm particularly comfortable in, and I hear my swan song being rehearsed in the wings, if you know what I mean. And that's okay with me. And this is one of the reasons, although, as I think I may have said to you earlier, I do feel from listening to lots of my colleagues that the parties are beginning to drift back towards having hearings in person. Some of the assets of virtual hearings will persist for certain parties, but I think others that I think may be more sophisticated value the kinds of things that only happen when people are together in a room. To get back to your original question, if you're an ad hoc arbitrator, as I often have been, and don't really have the opportunity to have much sense of the parties' advocates as individuals, I don't know them by reputation. I might know their firm by reputation. And I certainly haven't had the opportunity to spend much time with them in the past. I'm a little reluctant to become aggressive about a settlement. So much of my career as a mediator, I have a great confidence in my gut. And I don't have a gut when I'm with a stranger, and I don't know how it's going to be received. So I become careful. And I don't really like to go through ritual behavior in which I always say the same thing in the beginning of a hearing. I try to let things proceed organically based on the feelings that I get as I spend more and more time in the room with people. So I don't say something automatically at the beginning about, have you tried hard to settle this or something? I don't know who's going to take offense at that. I don't know who's going to worry about their client or their member when that conversation comes up. I just feel too naive and uninformed, and I don't want to touch a nerve with it I didn't even know is exposed. I worry about that. There does come a time, and I'm just speaking for myself, not arbitrators in general, when I have this really strong sense that people are wasting their resources on the case that I'm hearing. That there's an obvious sort of almost mutual gains kind of conclusion that they can reach, if nothing else, to save paying me and paying each other and so on and so forth, because it's obvious how the case is going to come out. And it's obvious that it's not a case of great moment. It's just a case that somebody feels they have to proceed with in order to protect something. They have to go through the motions. And if I say, I think that this is you're wasting resources, somebody in the room who's sensitive to wasting resources might hear me say that, and I might proceed accordingly. And if they want me to help them, I'll help them as a mediator. But I'm also not going to be aggressive about that, because I know that people have a variety of feelings about using a decision maker in a settlement effort when you're going to have ex parte communications and stuff like that. So I hopefully am sensitive to those opportunities, and I think they can be valuable to the parties. But I handle those in a gingerly way because I really want to know who in the hell I'm dealing with when that's going on and what their sensitivities are, particularly their internal politics. I think part of my training was to be very respectful of what was going on. I couldn't expect anybody to explain to me that there are things going on that I'm not going to know, and that those things are important, and I should not fools rush in. And I didn't want to be that kind of a fool.
Well, it also makes me want to have another go at this sometime in the future, Howard, where we talk more about mediation, because then your attitude can be quite different in the way you prepare for it. Think about it. But let me keep on the arbitration track, because your insights are really helpful for the practitioners that are listening, the HR reps and so forth, as to how to approach this. If you, Howard, I'm going to give you, John, a chance to answer the same question. If you said, what are just 2 or 3 best practices or pointers or things that have been helpful to me as a neutral to make a decision, what would you tell the lawyer or the HR person or the union rep or the union lawyer that's presenting to you? Make sure you try to do this thing or these 2 things.
To me, the most important thing when I'm in the presence of those parties, in other words, at the hearing, is that they need to be working as hard as they can to make sure I understand what's going on. Okay, they can't be talking to each other. They can't be using jargon. They have to know that I might screw up if I don't understand. I mean, I might screw up even if I do understand, but it's more likely, I think, if I don't understand, and it's up to them to make me understand. That's one thing.
Oh, I love that. That's great advice. I can't tell you how many times. Yeah.
I think it's a reason why I ask questions. It's not always because I really want the answer. It's because I want you to know whether or not I'm understanding what's going on, and my question should indicate to you whether or not I understand what's going on. So it's my sort of subtle way of saying to the advocate, I don't know if I'm keeping up here. Okay, that's why I'm asking this question. And next to having the court reporter screw up the transcript, it's the worst thing that seems to me that can happen. The other thing that I think plagues arbitration that I would speak to people about, and this is more on the union side, but I think it can happen on both sides, is what I would call conclusionary questions. I mean, I really just want the facts. And I want you to understand that I'm going to reach the conclusions. And if you ask the witness, did that violate the contract? You talk about something going to happen, then you say, did that violate the contract? Union people do this all the time. Somebody thinks that that's evidence of something. There's a slippage between what I think are my responsibilities and what they think are their what they think is affecting how I work. Those 2 things seem to me to be really fundamental to how a hearing is concluded, to just let me have the facts and then argue in the brief or in your final arguments. Just let me have the facts. Unless you're speaking to somebody other than me, don't be asking conclusionary questions. And the other thing is worry about whether or not I'm keeping up during the course of the hearing. Don't let me go home with the transcript and briefs and then figure out what the case was about. And all of those things happen.
I cannot tell you how many times after I've presented a case, the client would say, how did we do? And my answer was, we've associated the case with all of the facts that I think are necessary for me to argue for our position. And so that's really what I want to do. John, your turn. One or two things that you think are just essential, important, overlooked, however you want to take that question.
Well, I think from a practitioner standpoint, I think there's three things. One is understand your case, and working with witnesses, make sure that they understand. And I work with witnesses individually and as a group. I want them all to hear what the case is about, understand their role in reaching the decisions that were made and how we're going to present it. So understanding the case is important for the advocate and for the witnesses. Two, I think, know your weaknesses. No case is perfect. No case is so good that it can't be lost. So know your weaknesses. And I frequently want to be the person that talks about the weakness in my case before it comes out from the other side. I'd rather have it brought forward and disclosed and then just deal with it in a brief. And then the last thing, I think, we grew up in this age of Perry Mason and the witness examination stuff. That's not the way it is. As much as you want to ask a question, don't ask questions that you don't know the answer to. So I always tell people, lawyers that work with cases, and I've used this in my own cases, that use cross-examination very sparingly. Most cases are not won through cross-examination. Many cases can be lost through cross-examination, and the witness that you're examining is not going to help you with detailing the facts necessarily. So make sure that, get the facts from your own witnesses. Don't cross-examine to get facts. Cross-examine if somebody's lying and you can prove it. The arbitrator doesn't need to hear that testimony twice, but use it very sparingly. And in some cases, my client doesn't understand that. They say, well, why didn't you ask questions? And I'd say, well, because I didn't have any questions to ask. Nothing he would have said was going to help us. Nothing. So all it does is prolong the hearing, and the lawyer pounds their chest and feels really good about it. They went through a cross-examination. They made somebody cry, but that doesn't advance the cause at all necessarily.
Yeah, I remember a case way back when, and I had a really excellent cross. I had really undermined the report of an expert. The question that was lingering is, so now that you don't really support your own report, what would the report be that you'd submit? Because I undid all of the facts that he relied upon, but I was afraid to ask the question. I wasn't smart enough not to ask it. I was afraid of it. But the other side should have been more afraid because they asked the question. He became my expert at that moment.
I hear you.
So, yeah, knowing when to stop is important. One of the things, and then we could continue on for a while, but really briefly, do you want to do obviously an arbitration statement, which is, what is the issue? That's pretty typical. Howard, do you want to have an opening statement that summarizes what John or his union counterpart thinks they're going to do? Or do you want to just jump into the hearing?
I want opening statements. I really think they're extremely helpful when they're well done. I don't want the opening statement to sound like the closing statement with all the conclusions in it. I want to hear what you think you're going to prove and maybe some contract provisions that you're relying on or something like that. But in my practice, most of the time I have no idea what the case is about until you start to talk. And so that's really, really important for me as I move forward. And also, frankly, it's useful to me when the advocate after the opening statement asks me if I have any questions, because I'm likely to have questions about the opening statement. And if they're important to me, they're important to you, those questions.
That tells me that a whole bunch of advocates don't spend enough time on their opening statement. What do you think, John?
Well, I think that's probably true. I'm not one of those. I think it's the roadmap. And I recall a case, there's an arbitrator, again, that Howard knows well. One of the most impatient people I've ever met in my life. He lives here in Madison. I was doing a case in Sheboygan, and we presented our opening statement. And I said, here's what we're going to prove. Here's the issue. We've stipulated to the issue. I've explained the facts to which the arbitrator needs some introduction. And then I shut up. And then the union said, well, I'd like to do my opening statement too. So the union did their opening statement. And then the arbitrator said, let's take a time out here. Can I see the contract? And the arbitrator pulled up the contract, looked at the contract and said, well, I'm ready to rule based on the opening statements of the parties here. and I'd like to give you a bench decision. And we agreed to the bench decision, and we prevailed in that case, which is kind of a milestone for me. Is the only time I've ever really had a bench decision, and certainly didn't go in there with the intent of getting one. But it was, I heard what you've said. There's no dispute on what happened here. I look at the contract, employer, you prevail. And so that's the importance of that opening statement. Is I will, give the gist of my arguments in an opening statement, but I think Howard's right. He really wants facts. And the arguments are for either an oral argument at the end or a written brief.
Tom, I think you also asked about framing the issue. Yeah. And what I would say is that if there's an agreement on the issue, that's fine. I think it's a waste of time to spend a lot of time arguing about the issue in the hearing. I think the best practice is for both of the parties to present what they believe the issue is and then agree that the arbitrator will frame the issue ultimately in terms of first frame. But what I want to say is mostly if you get enamored of the notion of the issue, there's going to be a sort of fancy footwork that goes on where people are making word choices and linguistic nuances and so on and so forth that are going to ultimately trap the arbitrator one way or another. And I don't care to answer yes or no to a question that is formulated with that kind of gamesmanship.
Well, I get that. Hey, I think that it was not an unusual process. I worked for a pretty large firm here in Wisconsin when I started my career, and this might have been my first arbitration. And not surprisingly, I was given a dog, right? We're going to lose anyhow, so you might as well lose cheap. We'll get the cheap new lawyer in there. And I worked my tail off, but I knew that I had a loser. And so I went in and we put in our evidence. And the arbitrator said, gentlemen, I think it was two gentlemen, not a gentleman and a lady, would you like to submit written briefs or would you like to close with an argument here? And I thought, well, since I'm doing this on the cheap, the client will probably appreciate it if I save them a couple bucks by not going through and getting the transcripts and then writing out an argument and still lose. So I said, yeah, I'll offer an oral argument if it's acceptable to the union. Yes, we did. I submitted the oral argument, and I think, John, I did get a bench decision, which we won. So that's a little bit of brag story, right? But having said that, when do you decide, and what would you recommend to our listeners as to whether you would like to go to, getting the transcript and organizing over what can be an expensive process to put together a written argument, or when you might choose to have an oral argument summary immediately after close of evidence?
It's hard not to walk away from a hearing after it's over with thinking that you are inclined in one way or another. I think it's just human nature to do that. And I don't know if I can convince you of this or not, but it's not unusual at all to change your mind. That first impression is not what more thoughtful consideration provides, okay? There are nuances and complexities and things that may seem like minutia that turn out to be important, and you wind up deciding the case in the opposite direction of what your first impression is. So I think it's risky business not to give the arbitrator the full treatment of the transcript and briefs, because with those documents, as well as the record, that you have this opportunity to get it right. And I think that unless the case is of very little consequence, not doing that is what I would call a false economy. And just as a footnote to that, arbitrators are not good stenographers. And if you don't have a transcript, by the time the hearing is over, if it takes a few hours, the notes are going to be lousy. Okay, they're not going to be of any value when you get home 2 months later and you got the brief and you don't really have a record. So I think it's also very useful to have a transcript rather than depend on the arbitrator. Now, I know arbitration takes place, as you've said already, in lots of other settings, and in lots of other settings in commercial cases and so on and so forth. The protocols and the expectations and the mores are different than they are in the work that the three of us do. But in the work that the three of us do, I think when you have a case of consequence, you ought to apply sufficient resources to the case to allow the arbitrator a real opportunity to make the right decision based on all the appropriate factors.
Good. John, any further thoughts on that briefing or oral argument?
No, I've done oral arguments. I don't like them. There's a lot of pressure. You're tired after going through a hearing. You're going to miss some things. You can chart it out. Early in my career, I used to write the brief before I even went to the hearing because that told me what I had to prove. I don't do that anymore. I have notes, though, and witness checklists and things like that. But I think if you're trying a case that's worth trying, so it's a case of significance, you're going to have a court reporter there. Certainly, there's no reason to have a court reporter if you're going to ask for a bench decision. There's no reason to have a court reporter if you're not intending on briefing. I want a brief. I win cases based on my briefs. I love writing briefs. I'm a weird duck as it relates to that, but I think the ability to write something that's persuasive, grounded in the facts, is the goodness of our work, Tom. And I think that makes the difference in the right cases. And I think you can point things out that may not be obvious from a cold transcript. But I agree with Howard. I'd rather have a transcript. I'd rather have a written argument. I mean, if you're concerned about time and expense, you can agree on limiting the number of pages and having it filed quicker than the typical month, and it gets extended 3 times by agreement of the parties. I mean, all of those things are considerations here, but if it's worth fighting about and you're spending the money on it, let's do it right.
I love it, fellas. I'm going to end with something that's sort of a postscript to this, because we've really been talking about the process itself, but the process can sometimes be a substitute for what the National Labor Relations Board would decide, or at least the issue that might come before the board. And for all the time that I've been practicing, which is 45 years or so, there's been an issue of potential deference to an arbitrator's decision for something that might otherwise be under the jurisdiction of the NLRB. And consequently, one of the choices that parties can make, and if the hearing is conducted in an appropriate way and established in an appropriate way, you're never going to see the National Labor Relations Board. There is a deferral. For instance, an employee talks about discipline. That may certainly be under the contract, but it also may implicate whether there was discriminatory treatment because of the employee's action to support a union, for instance. Or there could be questions that come up in discrimination that's even broader than that might go to some other process. John, is that under the various changes we have from the Obama administration to Trump 1 to the Biden administration, now the beginnings of Trump 2, is that opportunity for bringing an arbitration rather than going through the board process still alive and well?
Yeah, I think it is. I think that, public policy favors arbitration as a dispute resolution process. And the law changed in 2014, then changed back in 2019. But there's the ability to have pre-arbitrable deferral, argue to the NLRB, because there's a joint jurisdiction issue when there's a claim of a contract violation. It's a violation of the contract subject to a grievance procedure. It's also a violation of the law. And so the NLRB will defer if you agree to have the dispute resolved at the arbitration level. But oftentimes disputes include not only allegations of contract violation, but also allegations of discrimination or interference with Section 7 rights. And Section 7 rights are the rights of employees under the law. And the NLRB is particularly persnickety, if you will, about making sure that those issues get resolved. So under the standards that exist today, the board will allow for pre-arbitral deferral, or they will defer to an arbitrator's decision when the proceedings were fair and regular, when all parties have agreed that that's the way they want to go, and where the arbitrator specifically considers the unfair labor practice issue, which is the question of a violation of the law. And the arbitrator's decision at the end, when rendered, is not clearly repugnant to the act. Standards that I think the parties have good deal of experience in dealing with. The question of whether it's a good idea or a bad idea remains. The current NLRB is changing. The prosecutorial focus and the emphasis on enforcement has changed with the new general counsel. The board will eventually change with presidential appointments. Might be a good way to have issues balled up for a long, long time, because you can always appeal board decisions to court as a way of prolonging the resolution. But if you're looking for a quick, cheap, efficient reason to resolve disputes between two parties in a relationship that continues, I think going to the arbitrator is the way to go if you get the parties to agree to that. And you avoid duplicate hearings.
John, thank you. I'm curious, Howard, you started out your career with the National Labor Relations Board, board agent and attorney. What's your thoughts on processes that also include, that is, arbitration processes that also include a deferral portion to them?
Lower level answer, a more practical answer is if you're going to present to me and argue about a case in which I have some responsibility for knowing the law, you better make sure I know the law. Don't rely on me to know the law. Okay, that's all I would say about that. I've been at it long enough to know how things change. There was a time in my life when I read what was called advance sheets that I don't think they exist anymore. And so every day we would look at the NLRB advance sheets and we would know where we are and all of that kind of thing. And I don't do that anymore. And I think most arbitrators don't do that at all. So I think you have to assume the role of educating me as to what you think the law is with regard to the issue in which the law pertains. Otherwise, I would say that not only is arbitration cheaper and more efficient and take less time and unappealable and all of those things that John was saying, I would also say, frankly, it's more sophisticated in its own sort of way, because my experience with the NLRB, having been there and observed that, is that the people there may have never been to a bargaining table. They have notions of good faith bargaining, which I had to purge from my brain when I became a mediator. I remember investigating good faith bargaining complaints or charges when I was at the NLRB and thinking that I knew what bargaining was about from taking affidavits of the parties who had participated in it. And then when I spent those years as a mediator at the WRC, I saw something entirely different and much more subtle and much more nuanced and much more complicated than what we were considering it to be at the NLRB. So I think that you're going to get a better analysis, a more incisive analysis from an arbitrator than you're going to get from a regional office. And I think that comes along with all of the virtues or strengths that John was indicated as well. But I know that there are cases in which there are reasons to battle. And if you want to battle for one reason or another, cynical reasons or wise reasons or whatever, the NLRB is a better place to have a battle. That's all I think. You know what I mean? You can sustain it and you can spend other people's money and all that sort of thing. It's litigation.
Excellent. This, I predicted before we went, quote, on the podcast, that we could have a 5-hour discussion. You fellas, I know that if we were over a beer and a steak or something like that, the war stories that I would allow that to take place would be a blast. For instance, I didn't say what was your quirkiest arbitration. I didn't say, John, who was your weirdest witness? Either side, union or management. That would be a blast. But even without that, we've been talking for a while, and it has been a delight to have you, Howard Bellman, and you, John Anderson, as guests on the Labor Law Insider podcast. Oftentimes I say, what's a practical pointer? I think you've laced our discussion with that for practitioners, for people who are saying, I want to avoid those darned arbitrations at all costs. Well, like you've already anticipated, it's about communication, even before you get to a grievance. So, folks, thanks so much for joining us. Howard, we really appreciate your participation in the Labor Law Insider.
Thanks for having me.
And John, it's always great to have my friend and my colleague join us and share a little bit of that wisdom learned over these past 40 plus years. Thank you so much.
Well, thank you. It was wonderful to be here.
And thank you for joining us on the Labor Law Insider podcast. I look forward to joining you again soon. Take care.